Welcome back, dear students. Today we will discuss the freedom of press and media as guaranteed in our constitution. Freedom of press or freedom of the media is a principle that communication and expression through various media, including printed and electronic media, especially published material, should be considered a right to be exercised freely. Everybody wants that there should be freedom of press and media. What is freedom of the press? The right to report news or circulate opinion without censorship from the government was considered one of the great bulwark of liberty by the founding fathers of the United States. Americans enjoy freedom of the press as one of the rights guaranteed by First Amendment. In India, the freedom of press is implied from freedom of speech and expression guaranteed under Article 19(1)(a) of Constitution of India. This article says that all citizens shall have right to freedom of speech and expression. Now the question is, why is the freedom of press important? Freedom of the press is important because it plays a vital role in informing citizens about public affairs and monitoring the actions of the government at all levels. Since 1970s, dear students, our Supreme Court through various case laws has bolstered the freedom of the press by establishing a heavy presumption against prior restraint. But freedom of press is not absolute. Citizens can seek redress if false statements are printed about them which damage their reputation. So, under the Indian Constitution, we will have to balance the liberty of freedom of press and the rights of the remaining citizens. So, there has to be a balance between liberty of press and order. United Nations 1948 document UDHR, that is Universal Declaration of Human Rights, states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media, regardless of frontiers. So, this is the mandate of UDHR 1948. Freedom of press, dear students, is the freedom of communication and expression through vehicles including various electronic media and published materials. While such freedom mostly implies the absence of interference from an overreaching state, its preservation may be sought through constitutional or other protection. The Indian press has a long history right from times of British rule in the country. The British government enacted a number of legislations to control the press, like Indian Press Act of 1910. Then in 1931-32, the Indian Press Emergency Act was passed. And during Second World War, that is period ranging from 1939 to 1945, the executive exercised exhaustive powers under the Defense of India Act and enforced censorship on the press. At the same time, The publication of all news relating to Congress activities were declared illegal. In the post-constitutional era, that is after the commencement of our constitution, there is a change in the outlook. The Constitution of India, in Article 19(1)(a), lays down that all citizens shall have right to freedom of speech and expression. Unlike the US Constitution, Indian Constitution does not expressly provide freedom of press. However, it is now well settled that words speech and expression in Article 19(1)(a) includes the freedom of press also. The freedom of press means freedom from interference from authority, which would have the effect of interference with the content and circulation of the newspaper. Article 19(1)(a) of the Constitution is subject to certain restrictions laid down in Article 19, Clause 2 of our Constitution. I will illustrate this concept with the help of this leading case, Ramesh Thapar versus State of Madras, decided by the Supreme Court way back in 1950, wherein the Patanjali Shastri, Honorable the Chief Justice, observed that freedom of speech and freedom of the press lay at the foundation of all democratic organizations. For without free political discussion, no public education, so essential for proper functioning of the process of a popular government, is possible. Dear students, in this case, entry and circulation of an English journal, Crossroad, printed and published in Bombay, was banned by the government of Madras. This order was held to be violative of freedom of speech and expression, as without liberty of circulation, publication would be of little value. So, order of the government banning the English journal Crossroad was held to be violative of freedom of speech and expression way back in 1950. Then another important case, Indian Express Newspapers versus Union of India, decided in 1985. It has been held that the press plays a very significant role in a democratic machinery. The courts have duty to uphold the freedom of press and invalidate all laws and administrative actions that abridge that freedom. Freedom of press has three essential elements. They are, number one, freedom of access to all sources of information. Number two, freedom of publication. And number three, freedom of circulation. There are many instances, dear students, when freedom of press has been suppressed by the legislature. Here is an example, Sakal Papers Private Limited versus Union of India. In this case, the daily newspapers, Price and Page Order 1960, fixed the number of pages and size which a newspaper could publish at a price. This order of 1960 was held to be violative of freedom of press and not a reasonable restriction under Article 19, Clause 2. You see, when the price of the newspaper is fixed, you are fixing the number of pages, you are fixing the size of the newspaper also. So this restriction on the number and size of the pages amounts to a check or violation of fundamental right of speech and expression and freedom of press, which is part of it. Similar is the case Bennett Coleman and Company versus Union of India. In this case, the validity of newsprint control order, which fixed the maximum number of pages, was struck down by the court holding it to be violative of Article 19(1)(a) and not covered within reasonable restrictions under Article 19 Clause 2. The court also rejected the plea of the government that it would help small newspapers to grow. The Union of India government placed a beautiful argument before the Supreme Court that if the size of the bigger newspaper is restricted, the number of pages of bigger newspapers are restricted, then probably it will help small newspapers to grow. Supreme Court said no. This is in total violation of fundamental right of freedom of speech and expression. Dear students, this freedom of speech and expression and freedom of press and media, both are interrelated. As reasonable restrictions can be imposed on freedom of speech and expression, similarly, restrictions can be imposed on freedom of press also. Because the freedom of press comes within the ambit of freedom of speech and expression. And in a democratic system, freedom of press is highly essential as the press acts as a watchdog on the three organs of a democracy, that is legislature, executive, and judiciary. But the freedom of press is not absolute in nature. It is subject to certain restrictions which are mentioned in Article 19 Clause 2 of our Constitution. The following are the grounds of restriction laid down in Article 19 Clause 2, and these restrictions can be imposed on freedom of press and freedom of media also. The first ground for imposing reasonable restriction on freedom of press is sovereignty and integrity of India. If by your publication, sovereignty and integrity of the country is affected or is threatened, reasonable restrictions may be imposed upon your freedom of press. Second ground is security of the state. Third one, friendly relations with foreign states. Fourth, public order. Fifth, decency or morality. And sixth, contempt of court. On all these six grounds, reasonable restrictions can be imposed on the freedom of speech and expression, of which the freedom of press, freedom of media is essential part. The grounds of public order and friendly relations with foreign states were added in our Constitution by Constitution First Amendment Act 1951. Whereas the ground of sovereignty and integrity of India was added by Constitution 16th Amendment Act of 1963. These grounds were added later on. Now, what is the current scenario of press and what are its achievements? We have discussed it earlier also that press is regarded as one of the pillars of the democracy as it acts as a watchdog of the three organs of democracy. Though freedom of speech and expression, including freedom of press, is enjoyed by the citizens, but there are many instances where the press has to face difficulties as well. In the recent past, you must have read in the newspapers that in the Tehelka case, the portal tehelka.com was forced to shut down completely, and its journalists were continuously harassed as the journalist exposed the scam in the defense ministry involving ex-defense personnel and central government ministers. So because of exposure of these high-fi people, the tehelka.com was forced to shut down completely. And in Jessica Lal's case, you see, Manu Sharma, the accused, son of a Haryana minister who killed Jessica Lal on April 29, 1999, because she refused to serve him liquor in the restaurant where she was working. Initially, the case was closed and all the accused persons were acquitted due to lack of evidences. But finally, if you remember, this case was reopened after media and public outcry, and finally it led to Mr. Sharma's conviction. So see the role of the press, that Manu Sharma, who was acquitted, the case was reopened when the media and newspapers reported, highlighted this matter. And second time when he was put to trial, Mr. Manu Sharma was convicted. Then, dear students, National Commission to review the working of the Constitution also has in its final report submitted to the government and recommended that Article 19(1)(a), which deals with freedom of speech and expression, must expressly include the freedom of press and other media, the freedom to hold opinions, and to seek, receive, and impart information and ideas. So, this commission has recommended that Article 19(1)(a) should be amended, and freedom of press, freedom of media, freedom to hold opinion, freedom to seek, receive, and impart information and ideas should be included in Article 19(1)(a). Now, dear students, we have understood what is freedom of speech and expression, and we have also understood that freedom of press, freedom of media is also an integral part of freedom of speech and expression. Now we'll see the expanding horizon of freedom of speech and expression by statutory legislations, or alternatively by the judicial response, by the cases decided by Supreme Court and various high courts. Dear students, in the Constitution of our democratic republic, amongst the fundamental freedoms, freedom of speech and expression shines radiantly in part 3rd of our Constitution. And this is a protection given to citizens against state suppression or regulation. There is a leading case, Prabhat versus Union of India. Good morning, ma'am. जी, all. जी. हाँ, Amita ma'am, Dr. Tyagi is in the class. Amita ma'am, please.
Hello. Good morning, ma'am. Okay.
So, dear students, in Prabhat versus Union of India, the Supreme Court directed the superintendent of Tihar Jail to allow representatives of few newspapers to interview two death sentence convicts under Article 19(1)(a), and Supreme Court held that the right to know news and information regarding administration of the government is included in the freedom of press. But this right is not absolute, and restrictions can be imposed on it in the interest of the society and the individual from which the press obtains information. So when Superintendent of Tihar Jail refused these journalists to meet Billa and Ranga, two death sentence awardees, so Supreme Court directed that it affects the freedom of press. The journalists should be allowed to meet Billa and Ranga. This was the ruling given by the Supreme Court. Dear students, in our country, the judicial craftsmanship owns the credit of widening the horizons of the freedom of speech and expression by including in it certain multifarious aspects. We have the example of Ramesh Thapar versus State of Madras, Brij Bhushan versus State of Delhi. These were the earliest cases to be decided by the Supreme Court, declaring freedom of press as a part of freedom of speech and expression. Now, what items are expanded and included in the freedom of speech and expression, especially freedom of press? So, items added are right to receive information is part of freedom of speech and expression. Right to reply is part of freedom of press. Right to compelled speech and right of convict to express himself. Right not to speak. Right not to speak and freedom of circulation. All these items are part of freedom of press and freedom of media. This right to access to the source of information requires that there should be no pre-censorship on the press. And this freedom in volume of the news, that is number of pages, if they are restricted, it affects the freedom of press. Then right of commercial speech. Commercial speech here I mean right to advertisement. It also affects freedom of speech. If there are too much advertisements in a newspaper, then it affects indirectly the freedom of speech and expression because little space is left for the news. Majority of the space is occupied by advertisements. Then right to fly the national flag is also part of expression, as held in Union of India versus Navil Jindal. And dear students, the right to broadcast is also part of freedom of press. Right to criticize is also part of freedom of press. Right to expression beyond national boundaries is also part of freedom of press. And right of the press to conduct interviews is also part of the press. Right to report the court proceedings is also part of freedom of press. So, dear students, if I may conclude, the freedom of speech and expression is the mother of all liberties. And freedom of press can be regarded as the very business of a democratic form of government. Truly speaking, our freedom depends in large part on the continuance of a free press, which is the freedom of speech and expression of individual or the press. But this right is not unfettered. Such freedoms are subject to reasonable restrictions, and one such restriction is censorship. So, dear students, Article 19, Clause 2 of our Constitution provides the basis for imposition of restrictions in the form of censorship. Consequently, so many laws have been enacted which provide for censorship of press and media. So, in a nutshell, the conclusion is that freedom of speech and expression includes freedom of press and media in it. But freedom of press or freedom of media as a part of speech and expression is not an absolute and unfettered right. reasonable restrictions can be imposed on the freedom of press also. And the grounds on the basis of which reasonable restrictions can be imposed, we have just discussed. So thank you very much, dear students. Thank you.